Good afternoon, everyone. This special called meeting of the House Judiciary Committee is hereby called to order, and we now have enough to have a quorum. Madam Secretary, please call the roll.
Representative Blanton. Present. Representative Bratcher. Representative Cantrell. Representative Decker.
Here.
Representative Elliott.
I'm here.
Representative Fisher.
Here.
Representative Hebron.
Present.
Representative Cole-Carney.
Present.
Representative Lewis.
Here.
Representative Maddox. Representative McCoy. Representative Minter.
Here.
Representative Mosier.
Here.
Representative Nemes.
Here.
Representative Petrie. Representative Scott.
Present.
Representative Stevenson.
Here.
Representative Banta.
Here.
Chairman Massey.
Here in the room. I'm going to dispense with all the niceties that we usually talk about with the phones and all of that, because we everybody that's here, I think, has been at many meetings and understands the rules. So with that, the first bill we're going to take up is Senate Bill 378. This is Senator Harper Angel's bill. It's also co-sponsored, I believe, by Chairman Westerfield. And with that, on her behalf, we have here Representative Rachel Roberts and her guest. I'll let you introduce yourself and your guest, and you can proceed.
Thank you. Thank you, Chairman. Thank you, members of the committee. I am here in Senator Harper Angel's stead today. I believe she's still on the Senate floor. Representative Rachel Roberts, District 67.
Yeah, and I'm Layla Cauchon, staff attorney with the Kentucky Association of Sexual Assault Programs.
Senate Bill 378 is a Crime Victims Compensation Board bill. It ensures that members of the Crime Victims Compensation Board and staff receive trauma-informed training to better understand the challenges faced by victims of crime. The training will consist of 6 hours within 30 days of being hired and 3 hours each year thereafter with agencies that specialize in victim advocacy. There are many such agencies who are willing to conduct this training at no cost so that the people who answer these calls and help us, victims understand how to do so in a trauma-informed way that helps them move through the system while not experiencing any further trauma.
We have a motion on the bill by Representative Nemes. We had a second by Representative Hebron. We have a dual second by Representative Hebron and Mackenzie Cantrell. Representative Cantrell. All right. With that, there is no sub, so I'll look and see if we have any questions. Seeing none, Madam Secretary, please call the roll.
Representative Banta.
Yes.
Representative Blanton.
Aye.
Representative Bratcher. Representative Cantrell. Yes. Representative Decker.
Yes.
Representative Elliott.
Aye.
Representative Fisher.
Yes.
Representative Hebron.
Yes.
Representative Cole-Carney.
Yes.
Representative Lewis.
Yes.
Representative Maddox. Representative McCoy. Representative Minter.
Yes.
Representative Mosier.
Yes.
Representative Nemes.
Yes.
Representative Petrie. Representative Scott.
Yes.
Representative Stevenson.
Yes.
Chairman Massey.
Yes, there being 15 yes votes, 0 no votes, and 0 pass. The same will be reported with favorable expression that the same should pass on the House floor. With that, you can also send the message to the senator that she can continue her good work in the chamber. I think they are talking about Senate Bill 1.
Thank you all.
With that, the next bill I'm going to carry on behalf of Chairman Westerfield. He's also on the floor, but he also has a prior scheduled commitment with his family this evening. That's Senate Bill 176, and that bill deals with facial recognition. And you got the bill in your folder, and you can see there what the technology is. And obviously, the initial discussion about that was there were concerns about freedom, constitutionality, and all of those things. The first thing I want to say is, A, this is for law enforcement purposes only. The reason it was brought to us, and I did see a presentation on it, was because they believe it will help them stop the sexual trafficking problem we have in our country. And they believe that they can use photographs, they can use video clips, they can use TV clips, etc., to try to catch people that are sexually trafficking both men and women across our nation. But what this bill does is it sets up a work group that will have to review all of the policies and procedures regarding this, specifically the policies and procedures set by each type of agency that is going to use this. We already have facial recognition technologies, you might be aware, on your phones. And if you look at the last section on page 3, it talks about the section shall not apply to a generally available consumer product that includes facial recognition technology, provided that the facial recognition technology is intended only for personal or household use. So they've also cut that out. They will collect data as to how this is going to be used, and they're going to specify a process that requires law enforcement agencies utilizing this to compare publicly available or lawfully acquired images against a database of publicly available or lawfully acquired images. So this is not, as some people concerned about it, the big brother fear that some people might think it is. It basically is a technology that will allow them to scan imagery from public images that are already out there, people that are on TV, people that have had news articles done about them, potentially family photographs, anything like that, and track people that might be known as sexual traffickers. All right, we have a motion on the bill by Representative Mosier. Do we have a second? I was coming back to you. Second by Representative Elliott. Okay, we have questions. Representative Blanton.
I don't know if you know the answer to the question since you're not the bill sponsor.
Well, I will give it my best shot.
Well, I'm noticing on this work group that they're putting together to study this, there is a very crucial group that's not included in that, and that is someone representing the state police. You've got all these others, the chiefs of police, Department of Criminal Justice Training, League of Cities, you got county judges, you got sheriff's office, and most likely if something were to come to fruition with this type of technology, KSP might end up being the only agency in the state that even has it available to provide service to these other agencies. Why would they not have someone on that working group?
Actually, I concur with your assessment of that. That is something I think could fairly easily address. I think that we need to make sure that what I believe is, quite frankly, the premier law enforcement agency in the state to be involved in that process. Because I'm not the sponsor, I certainly don't have the authority to make that change, but I certainly would concur in your assessment that that'd be a good change to be made to this bill to make it even better bill.
And I will plan on doing so through a floor amendment.
All right, thank you. Representative Minter.
I have a similar question. The other thing that struck me as a strange omission is that there's no requirement that a civil liberties group like the ACLU, which has done a lot of work on this and certainly protecting people's personal information and civil liberties is their priority. So do you know why they've been excluded?
Again, the way I would answer that is I saw the presentation on the information and what it can do. I did not participate in the drafting of the bill. I believe we do have the drafter here, but that all being said, I don't think these are changes that would be of significant concern to the sponsor. Perhaps the way to address it is if Representative Blanton is going to do a floor amendment anyway, that we can look to that and address any of those deficiencies that might involve other groups. My experience with these types of groups is you want to find that special sweet spot where you have all of the right people, but not so many people that you can't be effective. And so how they came to the decision-making components of what groups were included or not, I am not fully familiar, but I certainly will carry that word to the sponsor, Chairman Westerfield. I think the idea is to get something in progress if we've got this available, and it will assist law enforcement in providing a very essential need for people that are being sexually trafficked or those kinds of circumstances, that we can help them. So I am not opposed to that at all personally as chair of this committee, but it might be a good way to deal with it in one floor amendment, especially in the waning days of the session.
Yeah, I'd very much like to see that.
Thank you
very much.
Representative Stevenson.
I have a question. And as the only thing I dislike more than agreeing with Blanton is agreeing with Nemus. But the question I have is along those lines. We could save ourselves a lot of time if we get those interested groups involved, like Defense Counsel. They know they've used this data before. I agree with stopping trafficking of women and girls. But man, on the other end, if we don't get their input, we're going to be right back where we started with a delay. So I would say the amendment to include additional groups, even if it means to find the sweet spot, somebody else comes off of this.
Representative Nemus.
Yes. So I think there's some glaring omissions here. In addition to the Kentucky State Police, you've got no prosecutors involved in this, and prosecutors are obviously going to have to take the information and prosecute. I think somebody from PAC should be on there, or the Attorney General. The Attorney General's office does a lot of the investigations for this kind of activity that we're talking about, and they're not on there. The Public Defender, ACLU, or some organization. It does say it can't be used under Section 3. I guess it's Section 132. Can't be used to identify somebody participating in constitutionally protected activities. But I think the big thing that I think we should have is these protocols that are going to be put together by this group is going to be given to the Department of Justice. But this is an area that makes most people on the right and the left extremely uncomfortable. Are they going to be putting cameras on lights, on street lights? Are they going to be put them on posts? I don't think they are, but I think this report has to be given to the legislature, and I think we have to give a stamp of approval before we allow any protocols or policies to go into place. So I don't know that, and maybe it's in here that I'm not reading it, but it seems to me like this is not ready for prime time, and so to speak, because we're given a great deal of authority to right now just law enforcement agencies, and I don't know that we've got the proper controls in place to make sure that they're not inadvertently or in some way violating the constitutional rights or doing an investigation that's improper. Not that they would intentionally do so, but I don't think those protections are in place in this bill. So it seems to me like it's not ready.
I have Representative Kulkarni.
Thank you, Chairman. And I just want to understand, this bill would create a working group to study the issue of facial recognition technology usage by law enforcement. And you mentioned human trafficking. Are there any other instances that it would be used in, or is it every instance, and are there any exceptions?
Oh, I think we would all have opposition if it was used in every instance by far. I did want to point out, to answer your question and to go back to Representative Nemus, on page 2 of the bill, starting at line 4, which is section 1.3, it talks about on or before January 1, 2024, the working group established pursuant to this section shall create and make publicly available a model policy by use for law enforcement agencies. And I think that's important because I think that obviously gets us back to the situation where we're back in session, number one. Thereafter, maybe one of the things we could consider in the amendment would be to push that back a little bit, kind of like we did with the child support bill, and make it a little later than January 1 of 2024, so that if we need to make some changes to the makeup of the board, even though we might have a floor amendment, we need to make some changes or to address those other public concerns, we can do all of that. I think that the idea is we want to move, but we want to move with deliberate speed so that we don't get ourselves in an inadvertent or unintended consequence of violating anybody's rights or responsibilities or constitutional rights. So I certainly will take that up with the sponsor. Again, I'm sorry that he can't be here. It's one of those things that they're convening, and we have, after today, 5 days left. So with that, I will turn it to Representative Blanton.
Just a few quick comments, hoping to clarify some questions and concerns that I've heard raised. So I've seen the demonstration. This type of technology, there won't be new cameras put up trying to capture. It won't be going in using driver's license pictures. What this technology would do, it would go online and it would search out any type of already public photographs of someone that's on the internet, that's out there, whether it's from a Facebook or a Twitter or an advertisement, but things that's already in the public domain. It won't be going in and searching documentations that are considered official documentations. And I would remind everyone, this would only be a tool. It's not the end all that says, oh, this is enough to go arrest somebody. This is a tool that they can utilize in their investigation, but they still have to, even if they can identify somebody, follow up with interviews and different things. Just simply by making the identification, that's not enough. They have to follow up and do more investigation. So hopefully that will answer some concerns about what this process would look like.
I will note that the drafter here is in the room. It's Matt Troublehorn. He does a wonderful job as a drafter with Judiciary, and he's here, so I'm sure he's hearing all of the comments that we're taking in, and he will carry those back to Chairman Westerfield. I also received a text from somebody that's watching that's closely associated with this that said that the absence of the state police was an oversight and suggested a floor amendment. So again, we're trying to build a better product here, and I think that we can do that if we work on this working group through the floor amendment, maybe push the date of the report back till we're in session again so that we can evaluate this. We certainly could also have a time in the interim where we can have a presentation on this for the interim joint committee and let the whole judiciary groups together see this, or maybe even have a demonstration as we move towards this piece. So with that, is there Daniel, Representative Elliott, sorry.
Thank you, Mr. Chairman. I guess my question would be, what weight would this working group
Good catch.
have, their findings, what weight would that have on the policy that would eventually be adopted across the state? Because it's indicating on page 2, section 3, that they would make available a model policy for use by law enforcement agencies. And so, and you may not be able to answer this, Mr. Chairman, but if the group itself is somewhat deficient in the membership, as I think some of our members have pointed out, if that working group has a significant weight in terms of the recommendations that they're making across the state, then it could be concerning if we don't have the group composed of the correct members and associations. And I agree with Representative Nemus. It seems like we have 5 groups here, and so I don't know that hopefully we can get that corrected in a floor amendment, but I don't know if at some point we begin to disagree on who should be involved and whether it's criminal defense attorneys and the ACLU and so forth. So I don't know where the senator is on that and how he came to this list, but that would just be the concern I would give.
I will also make one comment. I may defer to my good friend Senator Johnny L. Turner that's here, because he sat through the committee meeting in the Senate, and so he might be able to give a better light on that. In fact, he asked me today if I wanted him to speak on this bill at all. This is the facial recognition bill. We'll call yours next. But we are talking about the facial recognition bill, and where we are, Senator Turner, is that the group has asked why the state police weren't part of the work group, and then there were some other inquiries about other groups that might need to be part of this. I will tell everyone, because of my quick overlook, the report is not to come back until January 1 of 2024. So we're still going to have, obviously, time to work on this, not on the interim, but this will be a process that will go over the next 24 months. So we'll be able to do that. But Senator Turner, not to put you on the spot, if you're not comfortable with it, I understand, but you did indicate that you might be able to shed some light. You sat through the Senate committee hearing on the Senate Bill 176. So if you want to make any comments regarding that, we'd love to hear from you.
Thank you, Mr. Chairman. I'm Senator Turner from the 29th District. There were some discussions about some agencies not wanting to get in this at the beginning because it's going to be a policy looked at thing. And I believe that might have been one of the things that some of them don't want to get burdened up at the beginning because it's going to take effect sometime in the future. It's kind of new stuff, as you want to say. And that, I believe, was one of the comments. And I don't remember any specific other about that, Mr. Chairman.
One of the questions, and you can convey this back to Chairman Westerfield, it's very likely, more likely than not, that there will be a floor amendment to address some of the groups that this group felt would be appropriate to be part of that work group. Of course, I know that I don't know who's been talked to and who hasn't, I think the idea is we want to keep this moving, but we want to do it at a deliberate speed to make sure that nobody's rights are violated, to make sure that the policies are in place, that this committee, that the Senate Judiciary Committee can see the work that's being done and continue to move this forward. Does that seem to be a good assessment of what you've also experienced?
Well, as my experience as a lawyer on that Judiciary Committee, Senator Westerfield is the guy that reaches out to everybody in all the bills that we have. He really reaches out to the organizations, and I can't sit here and tell you all the organizations he's reached out to. So I wouldn't think that there'd be any problem with listing those, and he may have reached out to some that you may be asking about also, Mr. Chairman.
Thank you. Do we have any other questions? Seeing none, and with the understanding that we've talked about here today, Madam Secretary, please call the roll.
Representative Banta,
Yes.
Representative Blanton,
Aye.
Representative Bratcher, Representative Cantrell,
I'll vote yes, subject to some of the discussion that took place today. Thank you.
Representative Decker,
I'll vote yes to move it forward, but need those things addressed.
Representative Elliott,
Aye.
Representative Fisher,
Yes.
Representative Heverin,
Yes.
Representative Cole Carney,
Yes.
Representative Lewis,
Yes.
Representative Maddox, Representative McCoy, Representative Minter,
Yes, subject to addressing the things we've talked about today.
Representative Mosier,
Yes.
Representative Nemus,
Briefly explain, Mr. Chairman. May I?
Please.
Thank you. I want to make sure that what we've talked about is not just the Kentucky State Police, which that's important, but it's also the public defender, and it's also ACLU. But not only that, the January 4th, 2024 date, yes, it's right. It's another session, but it's right when we come into session. I think we need to be able to review the policy before it goes into effect, so that needs to be delayed. And I would say that my good friend, the representative from gentleman from McGoffin, who I agree with, I think it's probably the intent, but I don't see anything in this bill that doesn't that prohibits law enforcement from looking at surveillance video from my law office or from Walmart. And we know if there's a heinous crime, law enforcement, as we want them to be, is going to be very aggressive, as they should be. So we need to make sure that we know the policies in place. Are they going to be coming to my law firm and saying, hey, you've got a video surveillance, let me see it? And there's nothing in here that says, in fact, it says to the contrary, that says you can't use that information to get to probable cause in and of itself. That's in section 13A1. And so there's a lot of very, very serious implications here for our constitutional rights and our citizens' constitutional rights. And I don't think we should allow this thing to go into effect January 1st, 2024 without us seeing the final product to approve or disapprove. I'm going to vote yes to get it moving, understanding there's going to be a floor amendment not only to add Kentucky State Police, but to do those other significant things. And I will vote no and fight as hard against it on the floor as I can if we don't have that delay. That's extremely important. I know Chairman Westerfield is one of the people I trust more than anybody, so I know he's thought this through, but those are my thoughts. Thank you, Mr. Chairman. I vote yes today.
Thank you.
Representative Petrie, Representative Scott,
Thank you, Mr. Chairman. I'd like to explain my vote.
Please.
Thank you. I'm voting no because I have real fundamental concerns about racial bias and the algorithms of face recognition technology. I'll be a no today, and I'll see what changes are made on the House for whether or not I'll change my vote then. Thank you.
Representative Stevenson,
I will be a yes today, subject to the amendment.
Chairman Massey,
Yes. There being 14 yes votes, 1 no vote, and 0 pass, there will be reported with favorable expression that the same should pass on the House floor. I will personally make sure that I get with Chairman Westerfield to address these concerns, and with Representative Blanton if he is going to work on the floor amendment, which I would greatly appreciate, and then we can also take the input from the other parties that have participated here today. The next bill we're going to call is Senate Bill 245, and we were able to get Senator Turner here. I know they were discussing a very important bill on their floor. We're glad to have you here, sir, so you're welcome to our group, and we'd like you to identify yourself, and please proceed with Senate Bill 245.
My name is Johnny Turner, and I'm the senator for the 29th District in Harlan and a number of counties there in eastern Kentucky, and I appreciate you all allowing me to be here to present this. I had to leave voting actually to come to get this, and they said they would call me if I had to come back. Mr. Chairman and members of the body, I don't know how many of you are familiar with what they call EPOs and DVOs, but they're a big thing. And you have two sections now. 43740 was the original EPO section, and then they added 456, which is the one for basically non-married people, but has the same limited authority for issuing emergency protective orders and then domestic violence orders after that. Originally, back in my day when I first started practicing, you had to go get a temporary thing by filing a petition in circuit court. The EPO and DVO statutes, specifically the EPO, when you first take an EPO, it's very directive. Courts can only basically sign the paperwork. Statute does not permit them to do some mediation. We have a lot of instances where the police officer goes, even when there's no assault, just when it's an argument or something, and takes the word is used perpetrator for some people, but it's that human body that leaves. It's a human person that leaves. They can't take their clothes, can't do anything. They're normally set for 14 days out, and that's in the existing statute, for a hearing. The rules also provide that if that party misses, the judge shouldn't be available or what, it'll get extended for 14 days. I'm just telling you the process, and I've been practicing law 42 years. And so I saw it come into being and have been involved in it. Then if the next time you go to court, there's a lawyer involved and they have filed a divorce petition, then it gets transferred to we don't have family courts in our districts in eastern Kentucky. We have circuit judges. Then it goes to family. I'm up from there up to the circuit judge. In the meantime, I had a case where two boys were young adults in their teens playing basketball at a tournament. Their mother took an EPO, and their daddy couldn't go to the ball game, and they were very disturbed anyway. In the divorce, they ended up going and living with the daddy. That kind of stuff, you get kids at hospitals, accidents, anything. There's so many emergencies that occur nobody plans on, and the district judge, the family judge, or the circuit judge or district judge, whoever issues it, cannot modify it from that existing EPO. This language directs basically for the judge to consider at the first EPO, which is good for 2 weeks before they have to extend it, to take into consideration the fact that one provision says that the person who is being taken out, the police officer can assist them getting their clothes and what have you. Or if they've got two vehicles, he can get the car keys to take that vehicle so he don't lose his job from work. The other one says like in Harlan County, you live so close that you're going to go within 500 feet if you just drive down the street. You go to Walmart, you go anywhere, you won't be within 500 feet of each other. You go in the courthouse, you're violating that. And this bill provides the judge, at the request of the petitioner, nothing restraining the petitioner, at the request, can consider that. And that is, in my opinion, should have been done a long time ago. I tried to do it in 2000 or 2001 when I was down here in the representative, but it didn't get done then when I was serving as a representative. And this is not objectionable to domestic violence people. Westerville, Central Westerville, and myself have contacted everybody. We have no complaints, county attorneys, nobody in the system. In fact, everybody that we've talked to thinks it's a good thing to allow this to proceed so that it can save, because you can't go to a funeral, you can't go to the hospital, and if you can't get a judge to modify it in the meantime, it can't. The worst example I ever saw, and then I'll shut up, was a young man that his moved 5 miles away after his wife took an EPO. And I've represented more women than I have men, and but 90% of them are not abuse. It's other things that occur in my district anyway. You don't have a lot of abusive spouses. And sometimes it's the lady hitting the man. But anyway, I was in another courthouse, didn't know this, many years ago before I came down here in 2000 as a representative, in 99 as a representative like you all are. This young man was sitting there in court. He testified that, I was listening to him tell his story to the judge, that the wife got an EPO in him. He moved 5 miles away to his mother's, and the driveway was 100 feet long, so they let her bring the kids to the driveway entrance. His mother walked down to get them. And the kids were walking up, and the wife got very language that he didn't respect, or nobody did. She was cursing, and he just said, "Would you please quit and leave?" I was listening to this in court, not in the court I was in. Well, the circuit judge that was who it was before at that time asked him, "Did you say that?" And he said, "Judge, I just did that." He said, "That's a violation of the statute, and I've got to give you time in jail. I'm going to sentence you to 30 days in jail." And the man said, "Well, Judge, I'm a coal miner. I'll lose my job." He said, "Well, that's your fault. The law says I have to. I have to punish you." I then, as a lawyer, stepped in and said, "Judge, well, you don't have to send him to jail. You can give him weekends in jail and probate some of it, and don't make him lose his pay. These kids will get up, be on welfare. Everybody's going to be hurt worse than they should be." And he did then modify that. And that's the purpose of this bill being filed, the sole purpose of it. And it fits both for domestic,
Motion on the
married
bill.
people
Second.
and
We have a motion on the bill by Representative Elliott and a second by Representative Nemus. Are there any questions? Seeing none, Madam Secretary, please call the roll.
Representative Banta,
Yes.
Representative Blanton,
Aye.
Representative Bratcher, Representative Cantrell, Representative Decker,
Yes.
Representative Elliott,
Aye.
Representative Fisher,
yes.
Representative Hebron,
Yes.
Representative Colcarney,
Yes.
Representative Lewis,
Yes.
Representative Maddox, Representative McCoy, Representative Minter,
Yes.
Representative Mosier,
Yes.
Representative Nemus,
Yes.
Representative Petrie, Representative Scott,
Yes.
Representative Stevenson, Chairman Massey.
Yes. There being 15 yes votes, 0 no votes, and 0 pass. The same will be reported with favorable expression that the same should pass on the House floor. We have one other bill to take into consideration. I don't know if you want to assist in this one, Senator Turner. You're welcome to. If not, I'll try to present it through for Senator Wheeler. This is Senate Bill 80, and you have that in front of you. It's not a very complicated bill.
I didn't bring it with me. I left it in another.
We'll see if the explanation brings up any memory of this. He had a constituent in his district that it had passed, a young lady, I believe, and there was a issue concerning genetic testing.
I'm very familiar with that. Mr.
Okay,
Chairman.
so let me finish this, and I'll turn it over to you. And so with regards to that, you can see on page 2 of that bill that it talks about, specifically, I'm going to turn to line 21. If the Office of the Kentucky Medical Examiner determines the cause of death of the deceased person based on the results of genetic test, the coroner shall enter the information on the deceased person's death certificate for the signature of the State Registrar of Vital Statistics. What was happening is, because if somebody has a genetic condition, there may be preventative measures that other family members could take, of which they are unaware if they can identify this genetic connection. So he has brought this bill with respect to that to make sure that hopefully we can prevent, through the medical science we have today, deaths of others if it's related to a genetic trait. But with that, I'll turn the floor over to Senator Turner.
Yes, thank you, Mr. Chairman, and members of the body. It was a very sad situation where it was a young, I think, 18-year-old girl that just passed away suddenly. And there was no cause of death. So the family then went through the process of wanting to know what caused this young child to die. And it was determined it was something genetically that could have been found, but it never gave any signs or symptoms to the child. But it was one that could get passed on, and other members of the family could have it. And so that's the purpose of the bill, then to require the autopsy whenever it's no death reason can be determined by any other act and sent to Frankfurt, so that there can be a determination. And they limited it to age 40. So it was a cost analysis was made, and 40 is normally the age that you would have siblings younger that it would apply to. So the bill is a good bill. It was brought to the attention, and nobody was aware of this fact that the autopsy wouldn't be performed by the Frankfurt office. So that was the purpose of the bill, and it actually came to fruition because another child in that family was found to have that problem, but it was corrected prior to her demise.
Bill by Representative Blanton, a second by Representative Lewis. Are there any questions? I did miss one thing. I on section 3, which is turn it over the last page. It says this act may be cited as the Micah Chantel Fletcher law, and I believe that's the name of the individual that we've kind of discussed. So I just wanted to bring that to the attention on behalf of Senator Wheeler before this committee. With that, Representative Nemes.
Yeah, I don't know exactly what genetic testing is. Is that an autopsy? And that's my one question. It also says that if the medical examiner does not determine the cause of death, the Kentucky State Medical Examiner shall conduct. I don't know if it doesn't violate mine, but are there any religions that have that they would have a problem with somebody conducting an autopsy on their body? So it seems to me that it would be better if it were shall upon request of the family conduct, because this would not allow the family to even object to it. So it seems, I don't know if there are religions that have those problems, but I think it would all be resolved, especially with the hypothetical that you just, not hypothetical, but the situation that you identified, if it said the state medical examiner shall, upon the request of the family, conduct genetic tests on the deceased person, because this doesn't give anybody an opportunity to object. And so I don't know the answer to those questions, but I don't want to require this kind of, if it would be traumatic to a family, that it's now required for the medical examiner to do that genetic testing, which I understand is an autopsy.
Well, the examiner can do it. They can do an autopsy. And Section 3 reads, if the office of the Kentucky State Medical Examiner determines the cause of death of the disease based on the results of genetic testing, the coroner shall enter the information on the deceased person's death certificate for the signature. And this only applies whenever the examination by the regular act of doing the postmortem examination by the office can't find a determination. Then they're to use the genetic testing to see if there is some determination, is my understanding of Representative Nemes.
Okay.
Representative Mosier might be able to comment on this too, Representative Nemes.
Well, I mean, in terms of whether or not the medical exam is performed, I think that's probably where the consultation with the family happens, not with the further genetic testing. So the family would have, it's my understanding that the family would have authority to either request or deny an autopsy initially. I don't know. I mean, perhaps in consultation with the family. I mean, because if someone has genetic counseling, you always consult with the family. In a living person, I don't know how it's handled with the deceased person.
And Mr. Chairman, I would feel better if that were spelled out in Section 2. Senator, is where I'm referring to. It says, is a postmortem, and maybe Representative Mosier knows this, is a postmortem examination, is that always an autopsy? I don't know. It doesn't seem like
that is.
Could there be a postmortem examination that is not an autopsy?
If it's a criminal investigation, probably.
Okay. I would feel a lot better if we put a little bit of the family's request in here, but
Can I respond to that, Mr. Chairman?
Yeah,
I think the purpose of that provision is, if you read that, it says, except in skeletal and decomposing. This is, it stops at 40 years after they've been decomposed, more than that. And I think that only applies when there is a body that's found that they're going to test, and that section applies to.
And I think if you look at on page 2, same section, section 2, sub 2, on line 15, that paragraph, except in skeletal and decomposing human remains in cases of a deceased person under 40 years of age, where a post-mortem examination is performed by the Office of the Kentucky Medical Examiner under the authority of the county coroner and the state medical examiner does not determine a cause of death, the Office of the Kentucky Medical Examiner shall conduct genetic test. It doesn't say they should conduct an autopsy. It just simply says they'll conduct a genetic test. So, Representative Heverin.
Thank you. As I was sitting here talking with Representative Kulkarni, I'm going to say we both have a question and let her follow up if there's anything else. But in Section 1, subsection 3, it says genetic tests, meaning tests of genetic markers for cardiac I'm not going to pronounce that, syndromes. I guess my first question is, wouldn't there be other genetic testing that someone could do? So I hate to just limit it. I would like to use that as an example rather than the only genetic test that we could make available. And then,
Do what?
yeah, I mean, that's really it, I guess. I would like to see a change in that in there, just so we're not limiting it to just the cardiac, if there could be more included in that.
That does make sense. Again, without having the sponsor here and not being able to do it here today, we certainly can consider a floor amendment to address that. Representative Kulkarni.
And just a quick follow-up, I was also curious, and I don't know the answer to this, but if we do expand the genetic testing, you know, if some are currently under this bill, if the genetic test comes up with some other condition, are they not allowed to disclose that condition because it's only referring to that, you know, that syndromes that are listed here?
So maybe the House floor amendment could kill.
Yeah, I think if we open it up to other conditions, we can amend it on a parallel front to make sure that those conditions are addressed as well.
Yeah. Representative can I make a comment, Chairman?
Yes.
Representative Nemus, I'm not in healthcare, but like I know that you can go to the doctor to get genetic tests to see like if you're more aptable to get breast cancer or different things like that. So I'd assume that would be genetic testing is very common. As I look at Chairwoman Mosher.
You may comment.
I can comment. I mean, this would have to be the definition of the genetic test. Wouldn't necessarily, I don't think, include BRCA or any cancer markers, because that would not be a sudden cause of death. You would have to define the genetic testing. It would have, I mean, if you want to be specific, it could get complicated to do this. You know, I mean, it's going to have to relate to a sudden cause of death. And genetic testing gets expensive. So I'm not sure where you want to draw the line.
There was a fiscal impact statement in this that's attached with the bill. I do think the recommendations that have come forward are good. I was told that in the Senate committee, they did have an expert that testified before that committee that went through all of these detailed markers and all of those kind of things that we're discussing here today. And of course, that might have answered some of the questions that this committee has. But what I hear from the group before we call for the vote is that they would like to consider possibly a floor amendment to address other genetic concerns and make sure that if there are other concerns, those could also be reported. Is that correct? Senator Turner?
I think the dollar figure that expert gave was about $300, Mr. Chairman, so it was not an expensive testing procedure. And in response to another question that was brought up, if there's a test done because of some kind of accident, that could play a part if the accident started something and then there was no other reason that the accident shouldn't have caused it, but they died. There's many ways that this thing could apply.
Representative Fisher.
Thank you, Mr. Chairman. Just a comment. The fiscal note estimates about 80 cases a year, and as you indicated, at $300 per test just for this cardiac arrhythmia test for the sudden death type of situation. If we start adding other conditions on this, we really don't know what the fiscal impact would be. So I'd caution against us adding any other tests until we find out what the cost would be.
It's my remembrance, Mr. Chairman, that the facility that's responsible for this said that there wouldn't be a problem financially. I think that's what I heard in the commentary between Senator Wheeler and the gentleman that came as the expert.
Well, we will, Representative Fisher.
But the testimony was just for this cardiac arrhythmia test, that there wouldn't be a significant fiscal impact. But if we include others conditions for testing, that's fair. Now, we don't know the impact of that, right?
No, Representative Fisher, I don't think that answer that expert gave was limited to that specific test. Now, I could be wrong, but I believe that was the fiscal impact met the test.
Representative Mosher, final comment.
Yeah, not to draw this out, but and I didn't hear the Senate testimony, but I'm guessing that the medical expert who came and spoke to this probably identified the cardiac arrhythmogenic syndrome as the most common reason for sudden death in someone under 40. I mean, we can consult with an expert if we want, but I am not an expert in genetics, but I'm guessing that that's what this is about.
And I apologize, Mr. Chairman, that I didn't get in all the details that Senator Wheeler did, and with my bills working others, I just remember some of it and don't remember it all.
We appreciate your testimony here today. That's very helpful. With that, are we okay? Madam Secretary, we're running low on battery, I'm told. So, Madam Secretary, please call the roll.
Representative Banta,
Yes.
Representative Blanton,
I'm voting aye to move this forward, but I really think in the future we need the bill sponsor here to be able to explain something.
We don't disagree.
Representative Bratcher, Representative Cantrell,
Explain my vote. I'm going to vote yes. And I just want to point out these past couple bills, we haven't had all the answers, but I think a lot of us in here have reached a consensus on what some of the problems with a couple of these bills are. And to use Representative Nemus's term, they're not quite ready for prime time. But I really appreciate how collaborative this conversation has been, even at this sort of later hour in the day. And I really hope some of these bills get worked on and keep moving. Thank you.
Representative Decker,
It's hard to vote on bills like this without all these questions, but I'll vote yes for the same reasons to move it forward.
Representative Elliott,
Aye.
Representative Fisher,
Yes.
Representative Heverin,
Yes, and quickly explain my vote. I really have enjoyed. I echo Representative Cantrell's comments. I was just sitting here thinking it's been a fun committee, just being able to go back and forth talking about issues, working amongst ourselves with both Republicans and Democrats. I think it shows KET that we are a family here most days, and so thank you for that.
Representative Kulkarni,
Yes.
Representative Lewis,
Yes.
Representative Maddox, Representative McCoy, Representative Minter,
Yes, and I concur with my colleagues. It's been a great conversation. Look forward to getting these things fully baked and ready to go.
Representative Mosier,
Yes.
Representative Nemus,
I have no idea what I'm voting on, so I'm going to vote no.
Representative Petrie, Representative Scott,
I'm going to pass.
Representative Stevenson,
Pass.
Chairman Massey.
Aye. There being 12 yes votes, 1 no vote, and 2 pass votes, the same will be reported with favorable expression. The same should pass. We will convey to Senator Wheeler the discussion that this committee had and recommend those suggestions to him.